Member for Vford South.
Mr. Speaker, I want to thank you. Mr. Speaker, I guess whatever comments this side makes would really be of no value just for the historical record, because in the past when suggestions have been made, they are routinely disregarded, and earlier this evening we were told, certainly I was told, that whenever suggestions are made, we make them with insincerity. We are insincere about these suggestions. So I don't hold much hope at all that the voices you have heard on this side will be listened to on what is a very provocative piece of legislation. Mr. Speaker, I also said in an earlier contribution that sometimes you get an impression that there is an accompanying schizophrenia when dealing with policies and legislation, etc. And if by schizophrenia we simply mean conflicting or inconsistent elements characterized by unusual disparity, then this bill certainly qualifies as being schizophrenic. Because on the one hand, it has made the requirement of obtaining an alien's landowning license exceptionally bureaucratic. But on the other hand, having made it bureaucratic, what the aliens get after the process is completed is immense, is extraordinary. I mean, simply put, for example, when you get what you call, I'll come to the technical term that is used, a certificate of entry or whatever it is, I'll come to that. That in effect, you are indirectly conceded permanent residence of the country by virtue of that. So you can come in as you want, as you wish. No restrictions, basically, on your movement. But I'll come to that. I think the point made by the leader of the opposition needs to be underscored. Dealing with land in St. Lucia is an exceptionally sensitive matter. And yes, he's right. I think small size, in a sense, feeds the insecurity and the concerns about land. Then too, there is the unique pattern of land ownership in the country, because the government of St. Lucia really owns very little of St. Lucia. Most of the land owned in St. Lucia is by the private sector. I can't remember, but it is possibly in the ratio of 70-30. So that in effect, the government itself, unless it purchases private property, let us say for housing development, finds itself disabled in its ability to deliver, because so much of this land is in the private sector. There's perhaps no national asset St. Lucians are as sensitive about as land. And the next thing, of course, as you know, is the Queen's Chain. And that is why successive governments have used the device of leases to grant access to investors to make use of the Queen's Chain. And one attempt was made to sell the Queen's Chain to a hotel in the south, I recall, Sugar Beach. And when the matter came to me, I indicated clearly to the developer that that cabinet conclusion would be ignored. It doesn't exist as far as I'm concerned. And the Queen's Chain may be leased, but not sold. There has been a unifying chord across governments on this matter, from the early days of the United Workers' Party under Sir John Compton down to more recent administrations. And basically that guiding principle was an overriding necessity to ensure there is control over land development and acquisition institutions. That because of the limited resources that we have, we've got to manage it and got to control it. That responsibility was assigned to Cabinet, again because of that sensitivity because the general feeling was that members of cabinet should not be taken by surprise if there is a major land transaction that occurs in the country. So this was the body entrusted with the responsibility to set policies for land development and acquisition. Now, Mr. Speaker, if you go back to the very first act that governed this matter, it is the Aliens Landholding Regulations Act of 1973. And of course, the point was made easily if you could look to Section 4. The Cabinet may, if it deem fit, from time to time grant to any alien a license to hold land as owner or tenant for any estate or interest, either subject to any conditions or not, etc., etc. That position was maintained in subsequent legislation. In 1999, for example, when some revision was done and a new act introduced, same principle. An alien may apply in the prescribed form to Cabinet for a license to hold land, a debenture, or a mortgage on land. Cabinet may, if it thinks fit, grant to an alien a license to hold land as an owner or as lessee for a term of not less than 2 years, or as a mortgagee, whether subject to any conditions or not. So the code remained through succeeding acts of Parliament, until, of course, we come to the current piece of legislation, the Aliens Licensing Act, Cap 1537. And for the first time, an adjustment was made because of the dramatic changes in the tourism sector. It was recognized, especially with your condominiums and etc., that there were persons who were purchasing land, aliens who were purchasing land, foreigners, of a limited space, less, for example, than in half an acre in some circumstances, whether, of course, you're dealing with the landings, or whether, of course, you are dealing with the property at Marigot, Capella, now Capella. And it says an alien may apply in the prescribed form to Cabinet for a license to hold land. Cabinet may, if it thinks fit, grant an alien license to hold land as owner or as lessee for a term of not less than 2 years, whether subject to any conditions or not. And then it said, despite subsection 2, the minister may, where the land concerned is not more than half an acre, grant an alien a license to hold land, whether subject to certain conditions or not, but the minister shall not, under this subsection, grant more than one license to the same alien. So that if that alien bought one property and proceeded to buy a second property, then that application had to go to the entire cabinet to be considered because of the fact that he was increasing his land ownership in the country, possibly to the detriment of seclusion. So that was the unifying code, that it was such a sensitive matter that the cabinet of ministers needed to have a say on what was happening to the patrimony of St. Lucians. That was really the crux of it. Now, Mr. Speaker, I have gone through that history just to emphasize that we have now made a dramatic change, and we are placing a powerful authority and responsibility into a subcommittee of the CIP board to make decisions about land and who should invest or qualify for land. Mr. Speaker, like my colleague from Castries South, I don't understand why a responsibility like that should be located in the CIP. Not only because of the reputation of the CIP and the current board, because it is not a reputation to be respected, but also that there are persons who want to purchase lands who have nothing to do with CIP, who don't necessarily want to be associated with a CIP. There are persons who, for example, might just want, they see a nice bungalow that they want to use for vacation purposes, may want to purchase, And as far as they're concerned, they just want to purchase their little holiday home and that's it. I heard the argument that the CIP has means of finding out about due diligence and so on, and they're well empowered to do that. But of course, suffice it to say that in any event, there are well-established agencies who can also perform that role, as has happened in the past. So the question is, why locate that huge and contentious power and authority in the hands of a CIP committee? As I said, not everyone who wish to purchase a house or condominium wishes to purchase citizenship in this country. But what I find particularly alarming is this now very bureaucratic approach. Now we are supposed to try to see if we can become more business friendly or whatever. So now it's a two-stage process. First, you apply for a certificate, clause 3A, of eligibility. And of course you can look at clause 3A and clause 7. Clause 3A says, without prejudice to the Citizenship and Investment Act Cap 120, the unit is responsible for processing an application for a certificate or an alien landholding license. Secondly, armed with the certificate of eligibility in hand, then you proceed and you apply for an alien landholding license, and that of course is captured in clause 15 of the legislation. An alien with a valid certificate or an attorney at law on behalf of an alien with a valid certificate may make an application to the board for an alien landholding license to purchase, acquire, lease, subdivide land, or continue to hold land in St. Lucia. So it's a two-stage process. The question then becomes, do you really need a two-stage process to do so? And why these additional stages along the path of getting an alien license? But there is a little sweetener at a point either before or after. Alien investors, even before arriving in St. Lucia, can apply for an alien investor entrance permit, clause 42. So, even before they arrive, they can apply for this alien investor entrance permit, clause 42, and of course, in applying under clause 42, they then get the benefit of obtaining a letter of support from the unit to explain that they are a bona fide investor. And of course, what the Act does is to place that application in the hands of the Chief Immigration Officer, but everybody knows that when the Chief Immigration Officer gets a letter from the CIP unit and that fellow is a bona fide investor, that the chances are he's going to get it. Now, Mr. Speaker, it is clear that once he gets it, and even though if he gets it for the duration of whatever license that he has, the reality is that it almost translates to a form of permanent residence because you can go in and out as you want. We have to be very careful here in St. Lucia that we don't develop social garrisons. We have to be very careful. We already have a CIP program that has a certain description, certain nomenclature. And so now, of course, through this device, investors have a means and a route of coming to St. Lucia, ostensibly to invest. Maybe there are those who believe that somehow all is at peace in this country. But we have to be very careful that we do not constantly aggravate our populations by creating what I call garrison communities in the country. This is something that I think we need to be very careful about. Now, as I said, it is this right to stay is automatically granted. And for confirmation, you could look, for example, if you want, Mr. Speaker, at clause 47.1, an alien investor entrance permit entitles an alien investor to enter and remain in St. Lucia for the duration of a valid license issued under the former Act on Alien Landholding License. So that establishes it beyond doubt. But just as a member for Castries South proceeded to clinically examine certain provisions and point out certain issues, I will select a few provisions which I think raises some questions. And perhaps we can start off with clause 22A. And I don't know whether the problem is a draft in one. The member for Castries South sometimes says it's a matter for lawyers, but there are some lawyers like myself who can be a little dumb sometimes, and it takes a little while for us to understand what it is being said. Clause 22. An alien shall make an application to the board for an amendment of a license issued under the former Act on Alien on the divorce of an alien to change the name on the 22. On the divorce of an alien to change the name on the license, the name of the spouse of that alien. What does that mean? Mr. Speaker, you tell me, what really does that mean? How could a mere divorce allow you to do that? I mean, I would have thought what was intended to say that on divorce and the alien land being settled or granted to a particular party, that party is entitled to request that the alien license be amended. Now, there is looseness in this that can produce serious problems. And yes, it is a problem. Because in the traditional alien landholding licenses that have been granted in St. Lucia, there have been cases where parties have divorced and the property rights have had to be determined. But of course, at the end of the day, once the evidence has been produced, what was the outcome of the divorce proceedings, then you proceed. So, I don't know whether this looseness of language should be allowed, or whether the term it is necessary to correct it. Then I want to go back to the much touted provision dealing with the role of cabinet. I have in my earlier statements indicated that I am concerned that there are insufficient points of reference in this legislation to the cabinet to cast an eye on what is happening with land in the country. I'm concerned. While I accept that we have to avoid a model of over-centralization, but there has to be some strategic points at which cabinet needs to be aware of what is happening and why. Clause 24 says, Cabinet may by order published in the Gazette waive the payment of the prescribed alien land holding license fee. A waiver under subsection 1 does not remove the requirement for an alien to make an application for an alien land holding license under section 2. Now, why clothe Cabinet with such arbitrary power in that sense? Now, I don't want you to get confused, Mr. Speaker. I'm making the point that Cabinet has to have strategic interventions, because this is a very serious matter when we are making lands in St. Lucia available to non-nationals with such ease. All I'm saying is, however, that if Cabinet is to publish an order waiving the payment of the prescribed alien landholding license fee, then ostensibly it ought to be doing that in the public interest. The old legislation had a requirement for public interest. So really, this should be saying, Cabinet may, by order published in the Gazette, waive the payment of the prescribed fee, alien landholding license fee, provided that it is in the public interest to do so. And public interests can, of course, include a multiplicity of scenarios, including that the land in question is vital and necessary for investment purposes, as in the past. Of course, Clause 25 does not and next cure the problem. It does not cure the problem in its entirety, Mr. Speaker. And in fact, it does not speak directly to the public interest point, although, of course, some requirements may be imposed. It says, for example, an order issued under subsection 2, and I'm reading clause 25.3, may be issued subject to any conditions that Cabinet considers necessary and shall relate to a particular alien or to a particular interest in land or both. Nothing wrong with that, provided that the overriding requirement of the public interest is maintained. Perhaps, Mr. Speaker, the most innovative aspect of this piece of legislation, and which has some value in my view, Mr. Speaker, is the establishment of the tribunal. Because in the past, very clearly, the matter lay in the domain of the Cabinet and the Attorney General's chambers, that is to say, in respect of forfeiture and the rest of it. But I'm a little puzzled. I don't have the anxieties of my good friend from Castries South regarding the membership of the tribunal. I think it is safer in the hands of the Chief Justice making recommendations in that regard. The problem, however, is clause 26.1. This is what it says. There is established a tribunal to hear a matter referred to it by the board under section 21.2. Now, when you go to 21.2, Speaker, it says, the board shall, on being notified under subsection 1, refer the matter to the tribunal for its determination. Then 21.1 says, where the physical planning, development division, and the development control authority have reason to believe that an alien or alien investor has breached the conditions of a license issued under the former Act on Alien Land Holding License, the Physical Planning and Development Division and the Development Control Authority shall give written notice to the board of a breach of a condition of that license. That's what 21.1 says. But, Mr. Speaker, if the tribunal is set up to hear matters only under 21.2, the question is, why not section 23 subsection 2 of the Act? Why set up a tribunal solely for that purpose? I mean, surely a tribunal should have more responsibility than that. If you look at section 23, Mr. Speaker, look at it for yourself.
23?
Yes. The board may revoke a license issued under the former Act on Alien Land Holding License, and it says for breaches of a number of things, some of them familiar. D, provides false information, is considered to be a national security risk, is involved in an activity that is likely to cause dispute to St. Lucia, and there are many of them around these days. And then there is the criminal conviction thing, and then it goes under 2. Where a license issued under the former Act on Alien Land Holding License is revoked under subsection 1, the board shall give written notice within 7 days to the alien investor of the revocation. A notice under subsection 2 must contain the reason for revoking the license issued under the former Act or an alien land holding license. So inevitably the question is, why is the tribunal not empowered to hear a matter under subsection 23.2 to test the validity of the reason given to the investor for the revocation of the license? Seems strange that you're going to have a tribunal of such eminent membership and it is only set up to determine if the interpretation is correct. But you know, the chambers of the AG, they have enlightened views, and so they may be able to tell us what exactly was intended or what is the purpose. Now, Mr. Speaker, there is a clause that perhaps we may pay scant attention to, but I think it's important that we look at it. It is the clause that deals with who is an alien, and at the same time the clause that grants an exemption. An alien is defined to mean a national of a member state, the laws of which require citizens of St. Lucia to obtain a license to own, acquire, or lease land in that member state. A firm, partnership, or unincorporated body of persons with more than 50% of its membership consisting of persons referred to under subparagraph 1. Clearly, that is to take care of the situation with the Treaty of Chaguaramas to grant other CARICOM citizens equal access to services, etc., within the community. It is true that that clause is faithful to existing practice, because the former government did establish that precise principle in dealing with CARICOM nationals. The reason being, Mr. Speaker, that some countries in CARICOM allowed St. Lucians on travel access to purchase property in their countries, but others did not. Barbados, for example, you could go to Barbados and subject to just paying your vendor's tax, you can purchase land in Barbados very easily. Other countries did not. They still required nationals to obtain alien's landholding license. And while, of course, Mr. Speaker, this appears commendable, nevertheless, I think you'd be surprised, Mr. Speaker, by the uncertainty as to which countries apply regimes of alien landholding licenses to St. Lucia nationals. If you ask any lawyer now, they can't tell you. And quite often the answer lies at the bosom of the Attorney General's chambers, who in turn may not even know and may have to conduct research. Perhaps, with all its faults, consideration could be given to an amendment that would require the minister to publish, Mr. Speaker, a list of countries exempted from the requirement for a license. So you publish it, it is public knowledge. A Jamaican comes in the country to buy land, they know whether they're exempted or not. A Grenadian comes in, they know whether they're exempted or not. And of course, you can do so by a simple order from time to time, and that saves everybody's time and everybody's energy, Mr. Speaker, to deal with this matter. So on the one hand, we have introduced now a rather bureaucratic procedure to obtain alien landholding licenses. And it is bound to cause delay to the process. I agree with my colleague totally and absolutely that it would have been better to place this somewhere else than the CIP. And the fact that it is there arouses concern and serious anxiety. And now you're saying that it is a subcommittee of the board that has to deal on a delicate matter, which for years succeeding administrations have said, look, this is too sensitive an issue. We need to know what is going on. For example, I don't see anything in this legislation that requires that a report be sent to Cabinet, whether it is on a quarterly basis or monthly basis, about the number of licenses granted. Of course, you can say to me, well, the physical planning department will know how many licenses were granted. That's a far cry from the Cabinet being advised directly that these are the persons who have been granted and these are the licenses that have been granted and where. Because this is a very, very serious issue. And I spoke earlier of the need for strategic points of intervention to protect the interests of Cabinet and by extension the country. And perhaps, as usual, it is all too late to make amendments, but I do believe that these issues need to be tackled along with the issues raised by my colleague. A law like this should not be uncertain. A law like this should be clear, should be precise. And the point raised by my colleague, whether an alien is now confined to buying land in a development, needs quick resolution. Because on my own reading of the legislation, I don't think the member from Castries South is really, really wrong. So, Mr. Speaker, what can I say? This will have serious consequences for this country, for the people of this country, for the citizens of this country. And in my view, Mr. Speaker, Cabinet should not abandon its total responsibility, wash its hands clean of scrutinizing what is occurring to lands owned by the people of St. Lucia in their own country. I thank you, Mr. Speaker.